Good afternoon, dear students of Kazakh University of Technology and Business. I'm the lecturer of the discipline, the legal system of the Republic of Kazakhstan. The topic that we are going to discuss today is the labor law and social security law in the Republic of Kazakhstan. So look at the slide, please. The purpose of the lecture is to reveal the content of labor law and social security rights in the Republic of Kazakhstan. We have several questions. First, labor law, concept, principles, subject, and sources. Second, individual and collective employment contract, concept, features, and types. Third, the concept and types of liability under labor law. Fourth, the structure of the labor code of the Republic of Kazakhstan. And the fifth, sources and system of labor law. Subject and method of labor law. Labor law is a set of legal norms governing the labor relations of employees and some others closely related to them, with equality of parties and the presence of powers of the administration established by the internal labor regulations. The subject of labor law is the relationship of employees arising in the process of their direct participation in labor. The content and nature of these relations depend on the type and form of ownership of the means and objects of labor. The method of labor law is consolidating the equality of the parties to the employment contract and the powers of the administration specified in the internal labor regulations. The object of the employment relationship is the performance of work in a certain specialty or qualification. Okay, let's move to another slide. The topic of this slide is the content of the employment relationship. It is the totality of the rights and obligations of its participants. So, the first thing that you need to know that the employee has the right on working conditions that meet safety and hygiene requirements, on equal remuneration for equal work without discrimination and not less than the statutory minimum remuneration, for rest provided by the establishment of the maximum duration of working hours, and paid annual leave, for social security due to the age and disability. And the last thing is to judicial protection of their labor rights. Let's move to another slide. Here you can see that obligations of the employee are performance of labor duties, observance of labor discipline, respect for the property of the enterprise. I think that the important thing that you need to remember that the basis for the emergence of labor relations are various legal facts provided for by the norms of labor law, of which the most common is an employment contract. In labor law, the subject is social relations that make up the labor process itself. Liability in employment contracts is usually disciplinary. Labor rights are protected by the Labor Dispute Commission and, in some cases, by the courts. So, as in other spheres of law, every sphere has its own codes. We have discussed with you civil code, administrative code, entrepreneurial code, and the labor code is not an exception. You need to memorize that there is a labor code. It is one of the main sources of the labor law, which regulates the entire range of social relations that make up the subject of labor law. The labor law consists of parts which are represented by various sections. So here you can see these sections: general provisions, social partnership in the world of work, employment contract, working hours, rest time, payment and regulation of labor, warranties and compensations, labor regulations, labor discipline, professional training, retraining and advanced training of employees, labor protection, liability of the parties to the employment contract, features of labor regulation of certain categories of workers, protection of labor rights and freedoms, consideration and resolution of labor disputes, responsibility for violation of labor legislation and other acts containing labor law norms, final provisions. Okay, The principles of labor law are the fundamental guiding principles which are associated with the use and organization of workers' labor. The basic principles of labor law are established by the Constitution. For example, the right to work, the right to be paid, the right to rest, the right to join trade unions, the right to material security in old age in case of illness, complete or partial disability, loss of breadwinner. Other principles of labor are cross-sectoral with principles of law. For instance, the principle of social justice in the field of labor, the principle of equality of citizens before the law, and, of course, warranty principles. Sources and system of labor law. The sources of labor law are normative labor acts of competent state bodies that establish and concretize mandatory rules of conduct. Laws, labor code, constitution containing fundamental provisions expressed in labor law, sectoral regulations issued by ministers and head of departments, local regulation developed by labor collectives. Local rules of law. Local legal norms are adopted by the administration of enterprises, institutions, organizations, jointly or in agreement with an elected trade union body, and individual regulations. Local normative acts establish provisions on bonuses, payment of remuneration based on the results of work for the year, vacation schedules, duration of additional vacations, and etc. Depending on the content, focus, and nature of these norms, labor law is divided into general and special parts. The general part includes norms that define the subject, basic principles, sources, content of labor relations, the procedure for concluding, and the content of collective agreements. A special part of labor law regulates certain groups of social relations. Norms governing an employment contract, working hours and rest time, labor remuneration, labor protection, and labor disputes. Look at the slide, please, and the main thing that you need to memorize is the law subject. The relations of employees arising in the process of their direct participation in labor. Objectives. Establishment of state guarantees of labor rights and freedoms of citizens, creation of favorable working conditions, and protection against unemployment, protection of the rights and legitimate interests of employees and employers. The tasks of labor legislation. Creation of the necessary legal conditions to achieve optimal coordination of the interests of the parties to labor relations, the interests of state. So, here are the functions of labor law. First, protective and regulatory. And second, educational. The employer forms the employee's labor behavior. Third is production, and the fourth is social. Tasks. I will not read all these tasks because I will send this presentation to you at home, and I think you will study this slide properly more at home. But I will say some tasks. For example, professional training, retraining, and advanced training of employees directly with this employer. Labor organization and labor management. Employment with this employer. The participation of employees and trade unions in the establishment of working conditions and the application of labor legislation in cases provided by law. Labor relations related to the agreement between the employee and the employer on the personal performance of the employee for a fee of the labor function. So, we have two parties of labor relations. First is employee. It is an individual who has entered into an employment relationship with an employer. Employer is an individual or legal entity, organization that has entered into an employment relationship with an employee. Some students asked me about labor capacity. And the question is that labor capacity arises from the age of 16. The exception is from the age of 14. So the employer undertakes providing the employee with work in accordance with the specified labor function. The employee undertakes personal performing the job function defined by this agreement. When we come to work, we always sign the employment contract. These are the things which need to be included into the employment contract. At first, full name of the employee and the name of the employer who entered into the employment contract. Specific place of work, date of work, name of position, specialty, profession, qualifications, rights and obligation, characteristics of working conditions, work and rest regime of the employee, the conditions of remuneration of the employee, types and conditions of the employee's social insurance. What is profession? Profession is the type of work activity determined by the nature and purpose of work functions. Okay. Qualification is the degree and type of professional training, level of training, experience, knowledge in this specialty. Look at the slide, please. You may notice that general provisions of labor legislation are based in the Constitution of the Republic of Kazakhstan and consist from the code, laws, and other legal acts. And if ratified by international agreement of the Kazakhstan, the rules of international treaty are applied. Okay, next slide. So, what are the terms of the employment contract? Uncertain term for the period of substitution's temporarily absent employee, for a certain period of at least 1 year, for the period of certain work, at runtime seasonal work, within the period of permits established by the legislation of the Republic of Kazakhstan. Okay, foundations of termination labor contract. Termination of an employment contract by agreement parties, expiration of an employment contract, termination of an employment contract on the employer initiative, termination of an employment contract on the initiative employee, violation conditions of employment contract, employee transfers to another employer, transition to an elective job, renouncement of employee from continuation labor relations. Okay, reduced working times for separate categories of employees. For workers who have not reached 18 ages per week. So if you are in the age from 14 to 16 or from 16 to 18, the time when you can work is no more than 24 hours. So just imagine the situation. If you are 16 years old boy or a girl, you can work only 24 hours per week. For workers employed in heavy works with harmful or dangerous working conditions, no more than 36 hours in a week. And for invalids of first and second group, no more than 36 hours in a week. Working more than 36 hours per week or 24 hours per week will be a violation of the law in our country. Okay, this is the end of our presentation. Your homework and test questions will be the concept of labor law, sources and basic principles of labor law, the right to work and guarantees of its implementation, the concept of an employment contract, the order of its conclusion and termination, timing in labor law, and that's all. Okay, dear students, this is the end of our presentation. Thank you for attention. Thank you for your attendance. We will meet on the next week. Goodbye.